the current conflict ongoing between Ukraine and Russia. Expert who will provide us with a lot of food for thought, I'm sure, and different perspectives on this conflict. We start with Professor Lauri Malksoo, Professor of International Law at Tartu University, and who possesses a very remarkable expertise to understand this conflict, because he's an expert on Russian approaches to international law. Then we will give the floor to Tom Casier, who is a reader in international relations at the University of Kent, who also possesses specialized knowledge on Russia, and in particular on the relations between Russia and the European Union. Then we will have the pleasure to give the floor to Dr. Alexandra Hofer, who is assistant professor in international law at the Utrecht University, who has a specific expertise in particular on enforcement measures under international law, which include what in the daily language we call sanctions. And last but not least, we will have the contribution of Sam Dubberley, who is currently managing director of the Digital Investigations Lab of Human Rights Watch. I have to rectify the information which was not updated, provided in the flyer produced for this event. Sam is no more with Amnesty International, but he's working with Human Rights Watch. He is an expert on human rights, and in particular on digital fact-finding. So I'm sure that the interaction between these different perspectives will be very enriching for all of us. Thank you very much for accepting this invitation under on such a short notice. Before I give the floor to the speakers, I would like also to stress that this webinar is the first result of a very intense, heartfelt debate within Brunel community, which has actively involved not only the academic staff, but also the students. All individuals, I think, who firmly condemn the scourge of war and are really shocked by the developments going on in Ukraine. My colleagues have worked very hard to make this event possible, working under time pressure, and to all of them, my deepest gratitude is addressed. A final remark, we will be together for approximately 90 minutes. Every speaker will have maximum 15 minutes to present his or her perspective on the conflict in Ukraine, followed by 5 minutes of questions from the audience. These questions should be formulated via chat, because only the speakers and the chair of the panel have the possibility to actively speak. All this said, I would like to give the floor to Lauri. He's a professor of international law, as I said, at Tartu University, but also member of the Estonian Academy of Sciences and associate member of the Institut des Droits Internationaux. He is also a national program director for Estonia of the European Master's Program in Human Rights and Democratization. Lauri has extensively published on international law, in particular on the international legal status of Baltic states, theory and history of international law, and on Russia's approaches to international law. Lauri, in his speech justifying the special military intervention against Ukraine, Putin has made several references to international law. Do you think that Putin is a good international lawyer, if we can say so? Please, you have the floor. Thank you.
Thank you so much for inviting me. It is a pleasure to be with you today. And indeed, in order to answer to your question, I was actually thinking to start my comments with a reference to a remarkable article that Vladimir Putin wrote in New York Times in 2013. And the context was that there had been, chemical weapons had been used in Syria. And this was the red line that President Obama had said, if it's crossed, then the US would consider a military strike. And then President Putin of Russia wrote in New York Times saying that whether we like it or not, law is still the law. And then he gave the conservative interpretation of what the so-called jus ad bellum norms in the United Nations Charter are, namely Article 2, Paragraph 4, that there is a general prohibition of the threat and use of force, and with only two exceptions, really. And this is the right to self-defense if an armed attack occurs, and collective measures undertaken by the UN Security Council. So in that sense, he knew, at least in 2013, what these norms are, and chances are that his kind of intervention in 2013 may have been one of the factors why in the end the US did not enforce that red line. So what has changed in the meantime, and why now in the end so blatantly Russia decided to go against these UN Charter norms that in previous years and decades have been very well known and often used as criticism against the United States, for example, in the area of jus ad bellum. One of the things that I have observed in my research, and that I tried to make a point in my book, Russian Approaches to International Law, is that when communism collapsed as a system of belief in Russia, it was initially there was a sincere attempt was made to kind of attach the country to those Western European, if you want, liberal values. And this was reflected in the 90s, for example, in such events such as the Russian Constitution of 1993, which in that version reads like a very, very decent constitution, actually, strongly presidential though. Or the decision 1996 to join the Council of Europe, and 1998 to ratify the European Convention on Human Rights. Scholars who observed Russia's interaction with different norms of international law started to notice areas of tension, though. Like there were many tensions in the Council of Europe system, but obviously these tensions also really emerged in those broader questions of world order pertaining sovereignty, pertaining the fundamental principles of international law and their interpretation. And of course, it did not help that Russia basically felt that with Kosovo intervention in 99 and with the Iraq war 2003, somehow I think Moscow felt that their procedural rights were violated too, because of the main idea that everything needs to go through the Security Council. So if it doesn't, it cannot be legal. So I guess there was frustration in a way on Russia's side, and then interestingly, those domestic political documents, national security strategies, and so on, they often kind of portrayed it in the way as if Russia were the guardian of international law, and certain leading Western countries somehow had they wanted to go unilateral. So this mindset must be also somehow taken into account. Now, what has happened over time is also that kind of decline of this thinking as if values could be universal, as if Russia could fully share Western values. And this is what I call the rise of civilizational thinking. I started to notice when reading, a number of textbooks of international law, it was always somehow juxtaposed. On the one hand, the West, on the other hand, Russia. And then, basically, it was obvious that in some ways, when Russia in those policy documents spoke about international law, it was partly something else they had in mind than what was the kind of liberal post-Cold War interpretation of those legal norms. And of course, everybody knows that one of those kind of values in which there has been a clash is sovereignty versus human rights and democracy. But I guess it is also not just any sovereignty, but also sovereignty of great powers, the sort of procedural equality of great powers. If you get to violate international law, then I get to violate too, if I want to. And it's also very strongly kind of, well, in a way, a Stalinist reading of 1945 United Nations Charter, which is, I think Stalin saw it first and foremost as an achievement of great powers. You know, the great powers, they win the war and then they create the world order, and they have special rights. And in many areas, you know, Russia's emphasis on international law has been extremely Security Council focused, and that means really that for the great powers, these norms are really political norms. They can use it against others, but basically already by definition, a Security Council permanent member cannot commit aggression, for example, because only Security Council can say so, that it is an aggression. Those civilizational traits, they were also, in thinking, they were also noticeable in some other areas, such as religion. Obviously, you know, when Marxism-Leninism died, then Orthodox Christianity restored its positions consciously as a sort of religion supporting, in a way, or the church also supporting Russia's statehood. And there's an interesting document that I invite everyone to study who has not done it. So in 2006, something was adopted called the Orthodox Declaration of Human Rights. The main author of it was the current patriarch of the Russian Orthodox Church, Kirill, in which he already declares that Russian civilization is a unique, independent civilization. Therefore, it has its own values. The document starts by deconstructing the concept of human dignity, saying that it's not inalienable, giving a different theological interpretation of what human dignity means. And in other contexts, in foreign policy, Russia and China in 2016 adopted a common declaration for the promotion of international law that I also invite everyone to study, because it tells you a lot about those conflict lines in contemporary international law. And it is, on the one hand, you know, this argument about state sovereignty versus human rights, democracy, values like that, but it's also an appeal that one should not somehow make a fetish out of judicially binding dispute settlement mechanisms, because political dispute settlement mechanisms such as negotiations are also, you know, good enough, and they should not be somehow dismissed. And I think it's also obvious that both Russia and China have been historically kind of reluctant in terms of submitting themselves to international legally binding dispute settlement. Now, could we have seen this coming? I think, of course, human beings are such that it helps us when we see later on what happens, right? Then we say, oh, you know, it had to lead to this, and I don't want to present this kind of fatalism here and you know, determinacy, but I think on some level Putin must have concluded that he got away in some ways with Georgia 2008, as well as Crimea, Donbass 2014, because really, you know, if you look at for example, the EU reaction to this Georgia 5 days war 2008, the Tagliavini report, it kind of really, you know, it in a way blames both sides. It does not, for example, highlight the fact, as it could have been, that based on the Uti Posidetis, South Ossetia was Georgian territory, is Georgian territory, and that in international law, you know, how could have Georgia restored sovereignty over its territory. So it was kind of trying to register some violations of international law really on both sides. This was the core message that came out of it. And in the case of Crimea and Donbass, did it really stop the Western world doing anything with Russia? Although it was really the first phase of what is now happening to Ukraine. Not really. And even my distinct colleague Alain Pellet in his blog post in European Journal of International Law kind of distinguishes between Crimea from the rest of Ukraine, at least in the sense that there hasn't been a massive resistance in Crimea to Russian rule. And I think my time is soon running out, but let me say that one interesting phenomenon, 2020 constitutional amendments in Russia. Really, what was their core idea? People were focused that Putin will be able to continue, but for lawyers, really what happened was that they changed the constitutional amendments, changed Russia's attitude towards international law. The constitutional version of 1993 really valued and emphasized international law and kind of said that when there's a conflict between international norm and the Russian domestic norm, then the international norm will prevail. And now it was 2020, it was basically reversed, using the idea that this does not apply to the constitution itself. And Russia started with those constitutional amendments. Actually, the very emphasis of the constitution went in a different direction towards different values, the same civilizational values compared to this constitutional version of 1993. And so in a way, I don't want to say that this was done directly in order to do this, but at least, in terms of constitutional law, one can now say that in the Russian constitutional system, constitution has priority over legal norms, and already the Constitutional Court has practiced it several times, in which they give this kind of sovereignist interpretation, which in a way supersedes Russia's international legal obligations. And I think I can stop here. None of what I said makes this what happened and what is happening less legal. This is simply for, or somehow, no, none of this makes it somehow legal, somehow justified. I'm trying only to understand what happened and where this violation, this major violation of international law came from. And my core idea is that Russians have started to see international law through a civilizational filter, which leaves, in a way, bad chances for the idea of universal international law. Because, for example, the civilizational idea that Ukraine should somehow be a cultural or civilizational appendix to Russia, for many of these people, supersedes the idea of sovereign equality of states, or that we do not use force against another nation because of the civilizational perspective. For these people, Ukraine is not just any other random nation, but in a way must get a special treatment, so to speak.
Lauri, thank you very much for this very interesting and thought-provoking introduction. While I'm waiting for the questions from the audience to be delivered, to be sent through the chat, I take the opportunity to start with the first question, if I may. Do you think, in general, that international law provides a way out to this conflict? And especially for our students who are attending this webinar, what are the obligations of the international community regarding the situation in Ukraine? Thank you very much.
I think there is no doubt that all these norms are there. They are valid. They continue to apply. But I think it is really the first time that we see so strongly, actually, since 1945, that one of the pillars of international law, and actually every permanent member of the Security Council is really a pillar of international law in this system. When they decide to go against it, I think the system was not designed for that. There are no perfect solutions. Of course, nowadays the international law is somehow it is shaping international public opinion, and international public opinion in turn can shape back our perception of certain events, our reaction to certain events, and already, for example, the fact that the General Assembly, based on the Uniting for Peace resolution, which is also in the title of today's event, 141 states out of 193 UN member states saying that this is Russian aggression against Ukraine. That's as big a majority as one can get, probably, in the United Nations in those circumstances. Of course, some people put hopes on the proceedings in the International Court of Justice of the United Nations in The Hague, but one needs to always keep in mind that the jurisdiction of the International Court of Justice is not unlimited or not endless. For example, Ukraine cannot sue Russia with the accusation with the request that the court would simply declare this war an aggression, because the ICJ wouldn't have jurisdiction for such a dispute, and therefore the current dispute in the ICJ is constructed based on the Genocide Convention. So basically, Ukraine has asked the ICJ to say that Russia has abused the argument that somehow genocide would have been committed in Donbass, that there is no evidence for that, and it will be a very important case for the ICJ, because really the question is, to what extent can international courts of justice, international law, bind great powers as well, or are they in a way out of it, maybe controlling it? We have one example from 1986 in the Nicaragua versus United States, in which a small country did score a kind of victory over a bigger country, and it was said that the big country, violated use of force rules and so on. But still, a lot of how international law will be enforced will basically also depend on the outcome of this war, because I would dare to say that international law doesn't have a great answer to the situation when aggressor wins. So it poses all those further questions, or if and when it wins, what should the other members do? Of course, there's a duty of non-recognition. So if they, already those Donbas republics, very few other states recognize that. But is there perhaps duty to do more? This is now what we will be, the main question that we will be facing, also seeing every day and every week those atrocities against civilians committed on the soil of Ukraine.
Thank you very much, Lauri. There are two more questions. One is formulated by Professor Alexandra Xantaki. I read it from the chat, and there is another by Dr. Solomon. Solon, will you ask the question in person?
First, a question by Professor Xantaki to be asked, and then my question.
Yes. So the question of Alex reads as follows: do you think that the international community should be more strict with Russia, or do you think that this would alienate Russia even more?
Well, I think that I already said before that I now think that the international community was perhaps not strict enough with violation of Georgia's territorial integrity in 2008 and Ukraine's territorial integrity in 2014. These were somehow more covert or milder, if you want, not so overt, not so open forms of aggression. And they used, of course, existing, I don't know, so-called peacekeepers in South Ossetia or the military bases in Crimea, Sevastopol. So it made it all, also from the military perspective, somewhat more complex. I mean, I definitely think that. So I think that aggression is this kind of crime in the international community that deserves conscious response. We should not try to pretend that aggression doesn't exist, and the response to aggression should be harsh if we want to maintain core values of international community. At the same time, of course, we must prepare for the future. We must see that we somehow don't condemn everyone in the Russian nation just by some sort of collective guilt because other aggressions have been committed in the past. Think of Hitler, and Germany also needed to have a future after World War II. So in that sense, we of course have to distinguish between the government, the state, and in the end the Russian people. But we also have to ask the very uncomfortable, unpleasant question: to what extent the political culture in Russia, or the way the empire has been nostalgically revived, has also supported these kind of decisions. Because when we look at the images, we can see that in certain segments of the Russian society, there is also support for this war, and that is probably a problem we have to also deal with. So the answer is nuanced, I think.
Okay, Lauri, thank you very much. I would like to give the floor to Dr. Solomon for a quick question and a quick reply.
Yes, thank you very much, Dr. Sullo. A quick question. I don't want to monopolize also to hear from the other persons who are also in the chat. Thank you, Lauri, for the introduction and these statements. But I'm tempted to ask this question now because you're an expert on this. It goes beyond international. It's about constitutional law. You mentioned correctly, in my opinion, that Russia gives preponderance to its constitutional law vis-a-vis international law. And you hinted that this may be a peril for international law, I think also correctly. The question is, in your opinion, as an expert in Russia and its attitude towards international law, how this preponderance of constitutional law differs from the preponderance that common law gives to constitutional law and to domestic law vis-a-vis international law. As we know, common law jurisdictions don't think that automatically international law applies to them, only international customary law. So do we have a different Russia? In principle, it seems to be the same, prima facie, but I assume it's different in essence. So thanks.
I think this is a great question, because especially that we are talking in an event of law school in London. And these kind of comparisons are very important to get closer to truth and to understand the situation better. And I think all these kind of concepts in international law, whether, for example, a country's attitude towards international legal norms is monist or dualist, they are some sort of abstractions in some sense, some sort of ideal types, ideal models. What it boils down to, I think, a lot is a country's history. So each country has had a different history and trajectory in international law. So sticking to your example of Great Britain, yes, it has had this dualist concept or attitude towards international law. For example, in the field of human rights, the Human Rights Act, that was necessary to really translate the European Convention of Human Rights in the British legal system. But at the same time, we also know from the previous centuries that Britain has been an active power kind of developing international law. For example, there is what is always interesting for me for someone coming from civil law country from a small country between Russia and Germany, is this kind of abundance of case law that Britain has produced, and that has also made international law very alive in your country. Now, what I think is characteristic to Russia, at least in the past, that there was a lot of, in different time periods, in a way rhetorical or even, let's say, propagandistic talk about how great international law is or what can it achieve, but it really went together with this kind of reality. For example, that there was a negation of international judicial mechanisms, very little really international court cases, arbitration cases like that. So I think that the 1993 Russian constitution was an attempt to raise the value of international law, and also use international law, including human rights, for reforming this former Soviet Union, the Russian part, basically as a help to strengthen those norms and ideals that the Soviet Union in many ways was not a fan of, such as civil and political rights and stuff like that. And I think this 2020, it really went back to the old model, which already prevailed during the Soviet period, which is that a country's relationship with international law is a sovereign matter. The last word must be with the sovereign. And once the sovereign discovers that, what it can do with that, it will be a bit like we say in Estonian, the more you eat, the more your appetite grows. I don't know if it's always true or not, but you definitely discover what you can do with it, and then you are tempted to use it even more. When international law really doesn't have priority over constitutional law, then you don't only use it in UCOS, but you also maybe use it in the prohibition of threat and use of force of the UN Charter. Why not? If you want to liquidate the greatest geopolitical catastrophe of the 20th century, like Mr. Putin said.
Lauri, thank you very much for your contribution and for sharing with us your thoughts. It's time now to move to the next speaker. I would like to give the floor to Tom Casier. Tom is a reader in international relations at the University of Kent, Brussels School of International Studies. Is also the director of the Global Europe Center, the research center of the University of Kent, dealing with Europe and the current global challenges it faces. The research work of Tom is focused mainly on EU-Russia relations, Russian foreign policy, and Eastern Partnership. Tom, you have the floor. Can you help us to understand what are the roots of the Russia-Ukraine conflict, and maybe what is Putin's final goal, if, of course, this is somehow clear? Thank you very much.
Thank you very much, Pietro, and good afternoon to all. Thanks for organizing. I think this is a very timely event, of course, and it's great you managed to organize this webinar so quickly. The question you ask is a difficult question to tackle, of course, because we're all, as analysts of Russia, trying to get our head around what exactly happened and how we can understand the change of strategy. And I would like to say a couple of things about sort of the broader context and indeed the reasons of how we can understand Russia's decision, Russia's change in strategy, and then maybe by the end make a couple of points about law. But I have to make a disclaimer here. I'm not speaking as a legal expert myself. I'm a non-lawyer on this webinar, but still a couple of points I would like to bring up, maybe on other aspects of law, such as the legal aspects of the post-Cold War security order. To start with the context, I think we woke up on the 24th of February in what is pretty much a new world. Even if we may not know how it ends, we certainly know what has changed and what has changed radically. And I would like to mention 4 different things. The first one is very obvious. That is that with Russia's invasion of Ukraine, we are facing the biggest war in Europe since the Second World War, which has started as an atrocious war, which is clearly a full-scale war. It has all the potential to become even more atrocious. 2 weeks and a half into the war, we have now 2.8 million refugees, which is an incredible number. And of course, we have a clear, blatant violation of both the United Nations Charter, the European border regime, and we have an act of war that clearly can be classified as an act of aggression under the United Nations Charter. A second element that indicates a radical change is the change in Russian strategy. If we go back to the time between 2014, the start of the Ukraine crisis, the annexation of Crimea, the war in eastern Ukraine, and 2022, we saw that Russia's strategy was very much about keeping a foot in the door. It was keeping some control over the capacity of Ukraine and Ukrainian government to take decisions by itself. It was about destabilizing Ukraine. It was about making Ukraine a liability for the West. Very much from the perspective that if they lost Ukraine to the West, then they could try to make sure that Ukraine would never be beneficial for the West, but would be a liability, would be a problem rather than an asset for the West. And that would also be a means, as part of Russia's strategy, to deter further NATO expansion, to deter the idea of Ukraine becoming a NATO member. Now we see a quite different strategy that, as I will expand on further, came pretty much out of the blue for many. That is that we now have a very clear policy of expansion. We had a discourse that put a very heavy emphasis on simply denying Ukraine's right of existence. Yeah, there was already the article by Putin last summer, but then in particular, the speech he held on the 21st of February, when he recognized the independence of the Donetsk and Lugansk People's Republics, was a speech in which he spent a long time on trying to explain why Ukraine was actually not an independent country, how it was a result of the Soviet Union and the choices that had been made then, and simply denying the right of Ukraine to exist altogether. And of course, another new aspect is that the new strategy of Russia is about no longer a limited military solution, but it's about a full-scale war over territory. And you could say before that, Russia had a policy whereby it very often tried to punch above its weight. It tried with limited means, such as cyber means. It tried to gain maximum results. Yeah? But now it's no longer about getting maximum results with minimal means. Now it's clearly about using maximal means for very uncertain results. And that's a very risky, but also a very new policy, a very new strategy on the Russian side. A third new element is that this seals the end of the post-Cold War security order in Europe. And it's very clear that this was already an ailing patient. This order was already crumbling down for many years, and I'll take some more time by the end, if I have enough time at least, to say a few more things about that. But it's very clear that the invasion now signals the end of the will or the hope to find any negotiated solution about European security, which was always one of the points that Russia emphasized over and over again. So the only thing that can result from the current war is basically a policy of confrontation, in the sense that there is no longer a common ground left for any negotiations on a new or redesigned European security order. This is simply the end of the security order that was already very much in decline. And the last element that is definitely new is the fact that the EU came up with a very united, very swift response with very far-reaching sanctions that were further backed up by decisions of private companies to withdraw from Russia, including BP. That's quite a spectacular example, withdrawing from the Russian energy sector as one of the biggest Western investors in this energy sector. The response of the EU was also transatlantically coordinated. And of course, it may signal the possibility for a new beginning, for a new reinforced European security and defense policy. Although we have to keep in mind that this new role for the EU will happen somehow in some sort of competition with NATO, because it's also the confirmation that NATO is not brain dead, as Macron suggested a couple of years ago, but that NATO has a role to play in European security. So why did Russia decide to invade? I don't think there are necessarily final answers. There's a lot we have to discover, because it came for many as a surprise, in particular, an invasion on that scale. I think quite some people had expected smaller military actions in eastern Ukraine, but an attack of the full territory with the means that Russia is using now came unexpected to many, including many Russian analysts very close to the Kremlin. Yeah? And there has been an enormous silence almost as of day number one from these Russian analysts. So it's good maybe to provide a little bit of background here. For quite some years, some experts, and Russian experts in particular, have been writing about the fact that Putin wanted a more permanent solution for the problem of Ukraine and for the problem in eastern Ukraine in particular, yeah, because we had a sort of stalemate over the Donbass, we had a stalemate over the Minsk agreements, nothing was moving, and there was a major discussion among Russian decision makers in terms of the final goals that Russia wanted to reach through its presence and support for these People's Republics of Donetsk and Lugansk. So there was a willingness to have a more final and more permanent solution for this issue, in particular because this strategy, which I mentioned earlier, the strategy of destabilizing Ukraine and keeping a foot in the door, didn't seem to work all that well. Yeah? And it, for example, didn't convince NATO to sort of withdraw its promise for NATO membership that it made to Ukraine. On top of that, we may have underrated, in the West, so to speak, we may have underrated the importance of the existential crisis Russia went through after 2014. Because Lauri mentioned already the civilizational thinking that predates 2014, but it got an enormous boost after 2014 and after what was seen from a Russian perspective, the loss of Ukraine, which is a very civilizational way of thinking indeed, but very mixed up with geopolitical arguments. Yeah? So what happened in 2014 was a deep crisis for the Euro-Atlantic community, but it was an existential crisis almost for part of the Russian public opinion, for some Russian intellectuals, and it gave a boost to an enormous intellectual debate in Russia over Russia's identity, whether Russia could exist without Ukraine, whether Russia could exist as an island, whether Russia could exist as a separate civilization, or whether, on the other hand, Russia needed Ukraine and Ukraine was an inalienable part of Russian identity. And I think this debate is something that has to a certain degree prepare the ground for the more radical action that we're facing now, even if it comes rather unexpectedly for quite some Russian analysts as well. We all know about the formal goals of Russia in terms of demilitarization, denazification of Ukraine. I don't think we need to go into that. It's very clear that this is mainly a discourse for domestic use, that Russia definitely wants to go far beyond that. In the early days of the invasion, there was some speculation about the goal of regime change, but I think it is very clear that Russia has plans to go well beyond that, that this is really about the dissolution of the Ukrainian state. And that, I think this will always imply inevitably a degree of Russian occupation or annexation in whatever form, whether it's through a puppet state or whatever, but I think the Russian boots will remain on the ground. And I think there are different reasons to say that. First of all, if we look at the statements, which I mentioned before, by both Putin, by Lavrov, clearly claiming that Ukraine has no right to exist, and you combine that with the way in which the war is being fought, the means that are being used, the fact that the entire territory is being tackled, but also if you think about the possible outcome of the war, where a situation whereby Russia will get this under control is very unlikely. And we may have a protracted conflict, continued instability, maybe some sort of guerrilla warfare. It's very hard to predict. But all this indicates that it is very likely that Russian military forces will have to stay and boots will have to stay on the ground. Even a scenario whereby a smaller Ukrainian state would continue to exist is something I find difficult to see, but of course we cannot predict, so I'm not speculating here, but even if there would be a smaller Ukrainian state left, it would be a sort of continuous security problem for Russia. They would have a very anti-Russian state on its borders, and it would only sort of replace an old security problem with a new one. It's clear that what Russia did, the invasion that it started on the 24th of February, is no longer about the European security problem it had been talking about for the last year. And actually, Russia has been talking about it in one form or another ever since the 1990s. Yeah, also under Yeltsin, Russia was opposed to NATO enlargement. The whole discourse of a threat of NATO and the red lines that Putin spoke about already in April last year, for example, seem already more and more like a sort of a pretext or some sort of distraction even, because now it seems to be clear that this is much, much more about getting control over Ukrainian territory than it is about European security, and certainly about renegotiating European security. By the end of the day, NATO membership was offered to Ukraine already back in 2008. That's 14 years ago. It was not on the table. Nobody was expecting, neither in NATO nor in Russia, that this membership would be offered anytime soon. So this was not necessarily an imminent security problem that was on the table. So I think the whole discourse about European security was mainly about building up a pretext for this invasion, much more than it was about real concerns about European security. And of course, through this invasion, by creating the biggest war in Europe since the Second World War, you cannot say that Russia in any way wants to find a constructive solution to a security problem in Europe. Yeah, this is creating the biggest security problem that we had since the Second World War. I would just like to add a couple of thoughts on some legal aspects. And as I said, I'm not a legal expert, so I would like to leave some thoughts about the role of the International Criminal Court and so on to my colleagues who are better placed to do this. But I just wanted to make a point about the legal framework that we have seen decaying over the last years, and for a complex set of many different reasons with responsibilities, I think, both in the West and on the Russian side. So I'm talking about all treaties that constructed a post-Cold War security order of some sort, mainly treaties that were signed and agreed in the late 1980s, the early 1990s, that were seeking to do different things. They were seeking to establish principles of the indivisibility of security after the collapse of communism, the idea of avoiding new dividing lines, in particular in the field of security. They were the treaties that were trying to set up a new collective security mechanism for Europe, something that clearly hasn't worked. We knew that for sure in 2014 when the Ukraine crisis started, when it was clear that there was no effective crisis mechanism to keep the crisis under control. There was no effective forum for talks between Russia and the West. There was the OSCE, but the OSCE certainly at the beginning of the crisis didn't manage to play a role of any importance. A third principle is the idea of the European border regime. That is, of course, older. You could say goes back to the Helsinki Final Act, which has been violated very clearly with the annexation of Crimea. But then in particular, I would like to mention the end of the arms control regime. Well, it has not entirely disappeared, but we have seen the steady erosion of the arms control treaties that were established mainly in the late 1980s and the early 1990s. I'm referring here to the Treaty on the Intermediate Range Nuclear Forces in Europe, the Treaty on Conventional Forces in Europe, the older treaty, the ABM treaty, from which the United States withdrew. So for different reasons, the Open Skies Agreement is another one. For different reasons, all these treaties have collapsed, because parties have withdrawn, because the circumstances have changed, with only one exception, the New START Agreement that is still standing and has now been prolonged, I believe, for 2 years. That's the last major arms control treaty that was still standing. And in particular, the Treaty on Conventional Forces in Europe is an interesting case, because this one was meant to avoid the possibility of a blitzkrieg of some sort. For example, providing for a prohibition of amassing troops on the border of other parties to the treaty. So it may not have stopped what is happening now. It may not have stopped or prevented the war in Ukraine, but at least it would have still played a role in terms of signaling that something was going on that by the Treaty of the Conventional Forces in Europe was unacceptable, that it was illegal under the treaty to amass troops on the border with Ukraine. And it could have made earlier action on the side of the West possible. To conclude, because I think I'm otherwise running out of time, just want to make a couple of very quick remarks to provoke some discussion maybe on where Russia stands in all this. It's interesting that Putin is now getting almost everything at the international level that he did not want, that he absolutely wanted to avoid. There is clearly a Russian loss of prestige, loss of credibility. Russia has undermined its own security concerns, which it has expressed over and over again. You're not credible any longer about security concerns if you start a war on this scale. We have a reinforced NATO and a united transatlantic front and a united European Union on the western side of Russia. We have Germany making its historical shift and investing 100 billion euros in its defense. We have a further isolation of Russia, and Russia has typically been a country that has been driven in its foreign policy by a fear of isolation, by being rather on its own and having no major other partners in the world. And there, of course, the interesting thing to look at will be whether this will weaken the links with China, yes or no. And China has kept low profile in many ways, has abstained in the United Nations Security Council, but it will be interesting to see whether Russia will keep any form of support of China, because in many ways, what is happening now is not very beneficial for China, given its investments in Ukraine, the importance of Ukraine for the Belt and Road Initiative, but also given Chinese principle of non-interference in domestic affairs, the importance of sovereignty, and so on. And Finally, of course, also the whole idea of Ukrainian identity, which was before 2014 in many ways ambiguous and unclear for many people and mixed up with elements and people coming from mixed Russian-Ukrainian families and so on. Russia has already strongly reinforced that identity in 2014. And now, of course, this goes a step further. And the flows of refugees going predominantly, almost exclusively towards the West very much underlines this point. So let me rest my case here. Thank you.
Tom, thank you very much for your thoughts and for your contribution. It's very interesting to listen to a non-lawyer because these perspectives complement each other so well. We are slightly running out of time, so I do propose to collect the questions at the very end, including the questions for Tom from the audience, in order to allow also the other speakers to make enough time to make clearly their points. And I would like to, at this point, to give the floor to Alexandra. Alexandra is assistant professor in public international law at the University of Utrecht at the Department of International and European Law. She's a member of the Utrecht Center for Regulation and Enforcement in Europe. She has received her doctoral degree in international law from the University of Ghent, and her expertise in particular include, among others, the law of international responsibility, sanctions, the use of force, the principle of non-intervention, and peaceful settlement of disputes. To start with, I would like to ask Alessandra, I give you the floor. Can you please help us to understand the countermeasures currently adopted against Russia, the so-called in the daily talk sanctions? Do you think they're effective? Are they unprecedented? What will be the long-term repercussions? Thank you very much.
Okay, well, thank you very much. Thank you very much, of course, for the invitation and putting this together. It's really a pleasure to appear before you today and to speak to you about these issues. So the effectiveness of sanctions. So that's the age-old question, I think. And actually, it's really interesting to note. So there's this book that has recently been published by Nicholas Mulder on the economic weapon, and he retraces the history of sanctions used as a tool of enforcement, especially in the League of Nations. And there already the effectiveness of sanctions was discussed. Sanctions were used differently at that time within the League of Nations because they were meant to deter states from going to war, rather than what we generally use them now for, which is we use them for multiple purposes, but at least in the context of Russia, it's a response to an act of aggression. So Nicholas Mulder's monograph is very interesting because what he shows is, whereas sanctions were meant to be used as a stabilizing tool in the League of Nations, they actually had the counterproductive effect of causing destabilization of the world order as it was meant to be after the First World War. Now, I found Nicholas's book quite interesting because in my own research, I have found that sanctions tend to also have a counterproductive effect, in the sense that rather when we adopt them in order to cause a country to change its behavior and to cease its wrongful act, these states that are targeted by sanctions tend to commit even further to their wrongful policy. So this leads us with that uncomfortable issue of how do we enforce international law properly? How do we do so in an effective manner? And I have quite a few ideas about that. Whether or not others will agree with me that they are realistic, I've often been accused of being naive and idealistic. But I think that this is perhaps something to touch upon and to leave for the comments, because trying to get a grip of what sanctions have been adopted against Russia, I have to say, so they started adopting these measures and they just kept increasing. So I kind of let it be for a few days, and then I went back to the drawing board to see what they had done. And my head was really spinning because these are really unprecedented sanctions that I've seen imposed upon a country, bearing in mind that Russia was already under a very stringent sanctions regime since 2014. It was one of the heaviest sanctions regimes that had been imposed on a country. So just focusing on the EU sanctions, because the other thing is that there's been, as has been mentioned, a lot of cooperation amongst states on how to respond to this aggression in Ukraine. So these measures have been adopted with cooperation from the US, from Canada, the United Kingdom, which has to adopt its own unilateral sanctions now, as it's no longer part of the European Union. Japan is supporting these measures as well, as are other non-EU member states that are in Europe, that are on the European continent and that are aligning. Switzerland, for example, has broken away from its traditional position of neutrality. But just to quickly go over the sectors that have been targeted, the sector that has been most hit by sanctions is the financial sector, because the EU has cut off 7 Russian banks from SWIFT. And also one measure that has really hit Russia quite hard is that transactions with the Russian central bank have been prohibited. Now, unfortunately, my economic course is long behind me, so I'm unable to explain what the economic impact will be on Russia, but having read some commentaries and some analysis, they're already wondering whether or not these sanctions will cause Russia to default. So the economic ramifications for Russia could be quite severe. In addition to this, there have been sanctions on Russia's energy sector, its transport sector, its technology sector. Now, with regard to energy, there's been this huge debate, at least in the EU, on whether or not to ban oil and gas imports from Russia. The EU has withheld from doing this because, of course, this would be quite severe for EU member states if they would do this. President Biden announced that they would no longer import oil from Russia. I believe this was confirmed, but I saw something before this comment that the signature so I'm not quite sure on where that stands. So I thought it was confirmed that the US would no longer import oil from Russia. Another novel form of sanction that has been adopted is the fact that the EU has sanctioned state-owned media outlets. So if you're in EU territory, you no longer have access to Russia Today or to Sputnik. And one of the reasons given for this is to prevent these media outlets from spreading misinformation, or at least information that would be supportive of the war in Ukraine. So the list I've given now are essentially sectoral sanctions, but I think it's worth mentioning that a large amount of, a very long list of individuals have been sanctioned. And so these are sanctions that impose an asset freeze and a travel ban on individuals that are believed to be high-ranking positions, or at least to hold positions of influence within Russian foreign policy. In a very rare move, Vladimir Putin and Sergei Lavrov were sanctioned, but their assets were frozen. So they did not impose a travel ban. And I think this makes sense in the sense that President Putin and his Minister of Foreign Affairs, they need to travel in order to exercise their functions. So if they had imposed a travel ban, they probably may have had some issues on the law of individual immunity. It remains to be seen. I don't know how many assets, to be honest, these men have in the EU. I'm assuming not many, because from what I know, Russians tend to be quite strategic, so they may have predicted that their assets would have been frozen. What they did not predict, I think, is that the Russian central bank would be targeted by these sanctions as well. So what I want to focus on in the discussion, I'm not so interested in the targeted sanctions against individuals. I'm more interested in the list of comprehensive sectoral sanctions, sorry for the Freudian slip, that have been imposed upon Russia, and in how the European Union has justified this. So in their own words, the EU, or at least representatives of the European Union, such as Josep Borrell or Ursula von der Leyen, have said that the purpose of the sanctions is to cripple the Kremlin's ability to finance the war, to hit Russia where it hurts with a maximum impact on its elites, to diminish Russia's economic base, and to impose costs on responsible elites. The EU has also said that its sanctions are smart and targeted. Now, I would have to strongly disagree with the EU in qualifying its sanctions as targeted. Now, perhaps taken by themselves, the series of sectoral sanctions, each on their own, could be considered targeted because essentially they're targeting a specific sector of the state's economy. But when taken together, these sanctions are closely resembling what we call comprehensive sanctions, which were, so for those of the audience who are not familiar with this kind of historical transition that occurred in the 1990s following comprehensive sanctions, which were essentially an embargo on Iraq. There was concerns about the impact that these comprehensive sanctions had on the Iraqi civilian population. It was quite controversial within the UN with highly placed officials quitting over this, saying that they didn't want to have any responsibility in carrying out a humanitarian catastrophe in Iraq. And all this pressure was put on the Iraqi state without this actually causing a change in the regime under Saddam Hussein at the time. It didn't cause a change in Iraqi behavior, and ultimately it was the people of Iraq who suffered the price, who paid the highest price for this. So then, in order to avoid this from happening again, there was a policy shift from comprehensive to targeted sanctions. And so the idea was then that sanctions would target those who are considered to be directly responsible for the policies in place. So sanctions essentially follow what I call, a rational approach to behavior, in the sense that the intention is to manipulate the cost-benefit analysis on the decision makers. So we make the wrongful behavior too costly for them, so that they will then choose the less costly alternative, which would be to comply with international law. And this is also something that's reflected already in that book I was mentioned before by Nicholas Mulder. It's very much this idea that states are expected to want to be part of the global economy, and so therefore, if we cut them off, that this will have a deterrent effect, or it will impose costs of them and manipulate their cost-benefit analysis. Now, the whole question is, are human beings and states are something I consider to be a collective of human beings. Are human beings are we so mechanical? Is it all about costs and benefits, or are there other non-material factors that influence our decision-making a lot more? And I think that when it comes to sanctions, these don't necessarily have the intended effect, which is why I call them counterproductive. And I'm willing to respond to any questions on that. But perhaps then on the legal aspects here, so I think what's important to know is that sanctions are highly unregulated under international law. So actually, there's no rule really that prohibits the adoption of sanctions. So sanctions are allowed as long as they do not cause the sanctioning state to violate an obligation owed to the sanctioned. So then this would mean that sanctions are generally acts of retortion, so unfriendly but lawful acts, or they could be an internationally wrongful act if they cause the sanctioner to breach an obligation it owns to the sanctioned state. So it's possible that some of the sectoral sanctions that have been listed would breach, for example, the GATT agreements, the General Agreement on Tariffs and Trade. Then there's the whole question of whether or not these measures could fall within the security exception that are found within the GATT. So it's basically something to be assessed on a case-by-case basis. Now, if these sanctions do cause, for example, the EU member states to violate an obligation they owe to Russia, there's no question of whether or not the EU could invoke a circumstance precluding wrongfulness. And the most relevant one here would be third-party countermeasures, meaning it's kind of, to use an analogy, it's like if you slap me, I slap you back. And my slap is justified because you hit me. So it's something that is very controversial. It's considered to be very archaic, but unfortunately, international law's enforcement is not so developed, at least in 2022. Let's hope that in a few years down the line, it'll be another story. But the problem is that third-party countermeasures, as I mentioned, are very controversial. And for me, it's an unsettled discussion on whether or not they're recognized under customary international law. The other issue is that in order for sanctions to qualify as third-party countermeasures, they need to meet a series of conditions. And these conditions are not always easily met. The one that I want to focus on here touches upon what I was discussing before, which is the impact that these sanctions could have on the Russian economy. And this is the question of the sanctions proportionality. Excuse me. And so, of course, then this idea then is that, if sanctions are adopted in response to a wrongful act, that they should be proportionate to what gave rise to the sanction in the first place. Now, obviously, and sometimes it's really hard to measure. How do we measure proportionality, for example, if we're talking about grave violations of international law? If we're talking about, an act of genocide, or in this case, a crime of aggression. Obviously, Ukraine's own economy and its own population will suffer greatly and are suffering greatly from the war. The question is if a similar impact is imposed on Russian society, on Russian economy, would that constitute a proportionate sanctioning? And it's a very gray area now when we consider, how the proportionality principle should apply to sanctions. I think perhaps some insight to the extent that these states are adopting sanctions in support of Ukraine, an analogy could perhaps be drawn from collective self-defense. So if they would adopt armed response under Article 51 of the UN Charter, normally any action taken in self-defense needs to be necessary and proportionate. So how would we calculate that type of proportionality? That could be something to consider. There's also, whether or not we take into account international humanitarian law. So normally, a proportionate response should not impact the civilian population this way. So there's a lot of open questions, and there's a lot that can be discussed. Now, what I do, I know my time is up, but the thing is also with this proportionality question is to what extent do we take into account whether or not the measures are necessary? And what do we mean by necessary? Well, it's like, in order they would be necessary to achieve their goal, their policy goal. And so to the extent that the policy goal is to cause the wrongful act to cease, would this, and if this doesn't happen, would this then have a negative effect on how we would consider the proportionality or the necessity of these measures? So this is, I'm going to end it here. But essentially with sanctions, it's a very gray area of international law. And I think that this is, again, one of the opportunities we have to look closely at the enforcement of international law and what are the appropriate tools we have in our toolbox. So thank you very much, and I'm happy to answer any questions.
Alexandra, thank you very much for your terrific presentation, which has provided really a lot of food for thought for the audience. There will be room for asking you questions in the very end of this webinar. Due to time constraints, I propose that we move to the presentation of Sam. I will shortly introduce him and then give to him the floor. Well, Sam Dubberley is currently working for Human Rights Watch as a managing director of the Digital Investigations Lab. He has been, until December 2021, the head of the Crisis Evidence Lab at Amnesty International, looking at using open source investigation technique across Amnesty's research work. His project on digital verification corps was awarded International Collaboration of the Year at the Times Higher Education Award in 2019, and the Innovative Teaching Award from the University of Cambridge in 2021. Sam is also a fellow of the Human Rights Center at the University of Essex, where he's a research consultant for the Human Rights Big Data and Technology Project. He serves on the advisory board of the Syrian Archive and the University of California Network for Human Rights and Digital Fact-Finding. I was sincerely impressed by his work in documenting human rights violation and by its impact, not only within the academic environment, but also far beyond. Sam, I give you the floor. Thank you very much for accepting our invitation. I was wondering how important is open source investigation concerning the alleged human rights violations committed in the conflict in Ukraine, and what is the work of the Digital Investigation Lab at Human Rights Watch more in general? Thank you very much.
Thanks, Pietro, and thanks everyone for inviting me to this panel. I guess my approach to compared to my three colleagues who've spoken is going to be a little bit more hands-on, a little bit more maybe micro, looking at kind of how organizations such as Human Rights Watch, Amnesty International, and others are looking at monitoring events on the ground, into the third week now of the conflict. I think, to answer your question in a way, Pietro, and let me start there, I think this in some ways is a moment where international law, international criminal law, international humanitarian law, international human rights law really needs to take notice of and start understanding the importance of video and photographs from a conflict zone. A lot of people have kind of been saying that this is new. Suddenly we're seeing this, deluge of video and photographic evidence, and as if it's never happened at a conflict before. I think that is, I think probably everybody in this call on this conference knows this is not the case. We've been in situations of using video and photographic evidence for several years since 2011, since the start really of the conflict in Syria. But we've also seen photographic and video evidence become really important in other conflicts, such as the ongoing conflict since 2020 in Ethiopia and in Tigray province. We've also seen photographic and video evidence be crucial evidence in 2017 in the Rohingya crisis in Myanmar, but also more recently since the coup in Myanmar in February of 2021. So increasingly organizations such as Human Rights Watch, other human rights NGOs on the ground, but also international bodies are starting to wake up to the importance of this information. Just last year, the first protocol was published on using open source information for investigations, human rights investigations, international criminal investigations. That's called the Berkeley Protocol. It was published in collaboration with the Office of the High Commissioner for Human Rights, and starts to set out actually methodologies and also a rigid protocol, or a rigorous protocol rather, on how to collect this information so it's useful in the future. And I think that's the important question, right? And Human Rights Watch, as an organization, sure, is collecting this information to report from the ground, to highlight potential breaches, to highlight potential war crimes that should be investigated by the Office of the Prosecutor or the Commission inquiry set up by the Office of the High Commissioner. And I think, obviously we can give that lead evidence. We can collect this information in the moment and analyze it and show what's happening. But also it's important that we understand that this information needs to be stored and collected in such a way that it can be used in future accountability processes and mechanisms. And I think this is new. This is something that's really new, and this is something whose moment has come. And it's important that lawyers, that litigators, but also judges start to understand this information and start to understand the process of verification. I think what we're seeing, which is very interesting, and this was kind of alluded to just before, is with the banning of some of the Russian channels in the European Union in particular, this idea, this kind of belief that, you know, misinformation, disinformation is being shared. As you know, nothing new. Misinformation, disinformation has been shared in conflict since the first ever conflict. You know, it's just got more voluminous. It's got more sophisticated. It's got more intelligent. And you know, one thing I was just reading earlier today is how some of the states involved in this conflict are actually presenting information, presenting disinformation in a way that's actually some of the methodologies we use and presentation methodologies that we use to present information which is actually correct and unimpeachable. So we get to a stage where, in some ways, in a conflict like now, in the digital age, where just kind of having the facts and knowing what the facts are is almost not enough. It's also about how we present the facts and present the information. And so this is where we're going with some of our future work, is not just thinking about how do we make sure that the videos and photographs that are being shared do show what it says it shows. And, you know, I can point to some of the work we did on cluster munitions use in Kharkiv last week, the published last week, and cluster munition use particularly looks like on the 28th of February in Kharkiv, and how we collected and presented that information. That's you know, cluster munitions is a fairly easy one, if you like. It's fairly low-hanging fruit. You know, the weapons in and of themselves are indiscriminate. There's a treaty which is attempting to ban them. So, you know, speaking to the use of cluster munitions is fairly relatively straightforward. Where the challenge comes is, of course, looking at proportionality and the proportionality of strikes, and then evaluating using also open source information techniques to evaluate, you know, if there was a legitimate military target in the area, and that's where it starts to become a little bit trickier, or at least our research has to be more rigorous. So what we're also doing always is corroborating that information with testimony on the ground. I have colleagues who are currently in Ukraine, who are kind of interviewing people as and when they're able to, in particular to these situations that we're seeing and we're documenting on video. We're using video and photographic evidence. But it's also about the presentation. It's also thinking about how do we present this information in a way that, sorry, somebody is pinging me on WhatsApp. I do apologize for that. It's also how we think about the ways in which we present this. So, you know, to answer the second part of your question, I suppose, and I can wrap up quickly, is almost like the role of digital investigations now are so important in a conflict like this one, where, you know, you have really solid communications infrastructure, where you have a population, as most of the world now, where with access to mobile phones and cameras, where we can actually, you know, collect or collate this information and log this information in real time. So that's kind of a very important thing. And then we verify it. So we go through steps such as called geolocation. So working out, we know exactly the street where this airstrike or cluster munition strike or whatever it is happened, that we know exactly when it happened. So chronolocation. So we locate it in time, often using satellite imagery and comparing the photographs and the videos to satellite imagery. But then we also have to think about the presentation and how we rigorously show, you know, something that is a video or a photograph where we don't know what happened before, where we often don't know what happened afterwards, but where we can actually take that moment in time and think about how, you know, what's happened around that, and where does a crime, you know, where does a potential crime start and where does a potential crime end, and how do we then present that in a way that can't then be dismissed as fake news? Because the other thing that we're getting as organizations such as Human Rights Watch is we're then being accused ourselves as we publish information of being fake news. So, you know, our reputation is probably some of the largest capital that we have. So spending that on being wrong is really, you know, we can't be doing that. So we are sure about what we say, and we are sure about the information that we collect, but we need to present it in a way that's almost unimpeachable. So I guess I'll wrap up there, and hopefully that leads to some questions about how we're working on the ground. Just to add that, you know, as I said, archiving this information, preserving this information in a way that then makes it usable in the future is really key. We're working very closely with a lot of other organizations or coalitions that have sprung up, both local organizations and international organizations. So there's a recognition now in the international community of fact finders, of researchers, of investigators, that open source information really is a key part of the puzzle and key part of the jigsaw in piecing together what's happening in a conflict like this.
Sam, thank you very much. I mean, this definitely opens new frontiers for human rights defenders and for individuals working in this field. And I would be very, very happy to listen more to you. There will be for sure some question for you in the chat. I would like to start asking some questions which have been formulating during the presentation. I ask, please, the audience to formulate relatively short questions and the panelists to formulate possibly relatively short replies. The first one is from Emiliano, and he was asking if there is, and I think this should be addressed to the international lawyers, if there is a real issue of self-determination of minority group in southeast Ukraine. This is the first question that I don't know who wants to reply.
I can start. I think in order to answer that question, we have to go back to early 2014 and look at the political debates. In the Western understanding of international law, let's say the territorial integrity of a country has generally kind of priority over self-determination claims, but it can there can be an exception to that if there are serious, very serious violations or denial of the voice of that people in a democracy. And I think that this simply wasn't the case in Ukraine at that time because there were certain tensions about Ukrainian and Russian languages. That is true, but in a way, the way already in 2014, when this Donbas situation emerged, Russia formulated it was more or less like a preemptive argument almost. We do that so that in the future there wouldn't be such a problem. So I think that of course diminished its value. And to add to that, what is especially fascinating to observe in today's Ukraine is that the Ukrainian identity now is firmly also based on the Russian language. So there's no difference in terms of patriotism, it seems, whether one is mainly a Ukrainian language speaker, for example, from Western regions, or mainly a Russian speaker from, I don't know, Kharkiv region, for instance, and which is also what I think Tom said before, that Putin has in a way contributed to the creation of bilingual Ukrainian identity, as a separate nation with clear, so to speak, distinct identity from Russia as a country.
Lauri, thank you very much for your reply. There is another question concerning real actual possibilities for accountability for the crimes allegedly perpetrated, and in particular, what role the International Criminal Court might play in this dispute. The question is not addressed to anybody in particular, so you can choose who replies to it.
I think our common interest is to get those responses to students. So let me just briefly say that in the ICC context, it's very unlikely that the ICC will be able to look at the crime of aggression, which starts it all, and in a way should be the main question, really, vis-a-vis, the Russian leadership, and in particular President Putin. But it has some relatively realistic chances, I think, over time to look at war crimes. And I think we will see cases, but neither Russia nor Ukraine are actually members of the Rome Statute. But since 2014, Ukraine has unilaterally declared, has allowed ICC to examine war crimes conducted on its territory, and I think by now it is so obvious that quite many war crimes have committed. It's also that the ICC, it is an interesting political move. They just some days ago they basically brought up again, actually from 2008, they named some concrete names from South Ossetian situation, military commanders who have been accused of war crimes. So their names were mentioned. I think it was clearly from ICC side a warning also to the military men operating in the current war theater that we are keeping an eye over what's happening.
Thank you very much, Lauri. There is another question maybe for Tom. Do you think that Russian stance would lead on the long run or can lead to creating a new world order?
Yeah, that's a difficult but interesting question. I think it will depend a lot, of course, in the first place on the outcome of this conflict. Yeah, as I said at the end of my presentation, I think in many ways this policy has the risk of weakening Russia rather than strengthening it, and in particular if it would weaken the partnership that Russia has with China, because this is not an alliance. This is very far from an alliance. And actually, on the very first day of the invasion, the Chinese Foreign Ministry was quick to point that out, that they had a partnership with Russia, but not an alliance. Yeah? So if that gets weakened, I think the chances for Russia to influence the world order will decrease rather than increase. Yeah? It's well known that Russia is a power that is quite unhappy with the international system, with the structures of international governance as they exist, and has been very assertive and provocative in challenging that system. But China, for example, is in a very different position. China is in a position where it is actually benefiting in many ways from the current international system, in particular in the economic field, with a fairly open global economy. That is the basis on which China has been rising very quickly. So if Russia runs the risk through this war of isolating itself further, the chances of influencing the world order will become smaller. Yeah? It will be more isolated, will have less of an impact. But of course, everything depends on the outcome of the war, and in particular then the outcome of this war in the longer term, yeah, how that will affect Russia's position, maybe not in the next couple of years. I think this will be inevitably a more isolated position, but how it will affect Russia's position really in the long term, whether there is any chance or any ground for a extended Russia to become stronger and have a bigger impact. But I don't see anything of that happening very soon, and certainly not in the current circumstances and under the current regime.
Tom, thank you very much for your very precise question. Now I have to ask, sorry, the most difficult question to the panelists. We are running out of time. Do you think we can accept a couple of questions more for the audience? Would this be possible? Thank you very much for your availability. Gerard, Russia seemed willing to accept influence by the Council of Europe, for instance, in penal policy. Is it more difficult now to make an argument about Council of Europe standards? Can arguments be made about this in future in a less political context? I don't know who wants to reply to this question. It is, sorry, it is about the relationship between the Council of Europe and Russia. We know that Russia has claimed that it would withdraw from it, and with also very severe consequences for human rights if they, of course, denounce also the European Convention on Human Rights.
I can say something. I mean, together, you mentioned before this, there's a master's program in Venice on human rights and democratization, and together with an Austrian colleague from there, Wolfgang Benedek, we edited a book in 2017 about Russia and the European Court of Human Rights with the subtitle, The Strasbourg Effect. You know, I'm now wondering if it's like, you know, can we still speak of a Strasbourg effect? Because in these days, I think this relationship seems to be coming to an end. But the truth is also that it was a process during which this relationship really deteriorated over the last 10 years. And in the last years, Russia's implementation of whatever comes out from Strasbourg has really been selective. It's on the one hand this constitutional court jurisprudence in you know, Yuko's case and others, in which they say that we will not implement this because of our constitution, which we understand in this and that way. And in that sense, it has already been a difficult relationship. Will it endanger also those achievements that the European Court of Human Rights helped to consolidate in the Russian society? Yes, I mean, look at how currently Russia deals with those demonstrations. I mean, you could see today the arrests, freedom of expression, freedom of assembly. Today was this fascinating video from near Kremlin, how a woman raised a little paper saying two words were written on the paper, and like in 2 or 3 seconds, the special police basically ran her down and arrested her because it was considered that it's a demonstration. So I guess rights in the Russian society itself also will become and have become a collateral damage of this turn, because I think the war is actually deeply unpopular, at least in some parts of the society. There have been many protests as well, and then I think the Russian state has responded with repression. And when you know, the possibility of the European Court of Human Rights also goes away, then basically these people are on their own. There's no way they will get a remedy from the Russian legal system currently.
Thank you very much, Lauri. There is probably time for a last question. I read from the chat. Sorry. Just one moment. Okay. Indeed, in the communication war that is going on, even the UN special procedures have problem identifying the extent of the destruction. Last week, there were news about the destruction of a Holocaust museum, but we could not be sure whether it was fake or not. But how does your project manage to find the real extent of these destructions? What are the tools used? Of course, the question, sorry, is for Sam.
Sure. Thanks for the question, Alexandra. So basically, open source research pretty much relies on information and tools that are freely available or very low, or come at a very low cost. So the great thing about this work is pretty much anybody can dive in, and I think, you know, that's really not to be underestimated. I think we've seen a lot of groups such as Bellingcat, such as news organizations such as the New York Times, the Washington Post, for example, really dive in and do some great work around this, and it's a very open community and a very sharing community. We also have organizations such as Forensic Architecture or Situ Research, who take it a step further and they integrate open source research into 3D models and that kind of thing, where, you know, it allows us to actually really visualize what's happened. So first of all, it starts with actually, you know, Telegram. At the moment, Telegram is a new tool. When I started doing this work back in 2011, it was YouTube, it was Facebook. Now we're finding information mostly on Telegram, but also on TikTok, on Snapchat. You know, we have to go where people are posting their information, where people are sharing their information. Then we use a lot of satellite imagery tools. So there's a freely available satellite imagery tool called Google Earth Pro, which allows you to look at satellite imagery from anywhere in the world. It's great for planning vacations if somebody would like to kind of get a feel for this work. But that's a freely available tool which has, you know, satellite imagery regularly updated from across Ukraine. What we'll be doing, though, is using some of the other more commercially available and more rapidly available satellite imagery. It's been very cloudy over Ukraine for the last 2 weeks. So, satellite imagery of Ukraine is actually, there's not that much of it, especially over the cities at the moment. So looking at the destruction of areas such as Mariupol or Kharkiv is difficult, but the clouds will lift. We saw that in Rakhine State in Myanmar in 2017 when the attacks on the Rohingya villages were happening. It was a rainy season, but 2 months later we could look at satellite imagery and make very clear determinations on which villages had been burned by the Tatmadaw, the Myanmar army, and which hadn't, and exactly how they were targeting Rohingya villages. Exactly the same will happen in Ukraine, where we'll be able to see the disproportionality, probable disproportionality of the attacks on civilian areas. So actually measuring the destruction is going to be a question of using the video evidence and using photographic evidence, but also really looking at satellite imagery and seeing how it was, what the area looked like in early February and what it looks like today. And I think when that does start to come out, we will really start to envisage and see the actual absolute scale of destruction that's been wrought on some of the cities of Ukraine.
Thank you very much, Sam. And there is a question for Alexandra also. And do you personally believe that the current set of sanctions will deliver the desired outcome?
Thanks for that question. Well, I would say it really depends on what the desired outcome is. If the purpose is just to impose costs on Russia for what is done in Ukraine, then absolutely. If it is to, exclude Russia, and also part of it is this exclusion policy, then I think that's being done. On the other hand, I think it's also interesting to look at how other states react to this situation. So this was briefly touched upon. I think it depends. If the idea is, we want Russia to stop its aggressive policies in Ukraine, I don't think it will have that effect, at least not on this leadership. Who knows if there's a change, and if there's other decision makers, then that's possible. I think because one of the things that have been noticed is Russian leaders' response to these sanctions is they basically frame it as a means to weaken Russia. And they say, well, we will use this in order to develop our own competences and techniques that we didn't otherwise have. And I know that, for example, the use of the dollar, so cutting a state off from the dollar in order to further exclude them, in the long run, it might take 10 years, I don't know how many decades that would take to develop, it might hurt the US's premise of the dollar, because states then try to develop their own currencies. So whether or not that's realistic, whether or not that will really happen, that's something that states are looking to. It's even something that the EU is interested in because it wants to avoid the extraterritorial sanctions that the US pursues. I did see there's some questions about, previous acts of aggression. I think that one of the important things is when we adopt sanctions, and this is a bigger issue as well, is this issue of since there's no obligation to respond to violations of international law, states do it when they want to. And this can lead to double standards. And this is also something that really strongly weakens the sanctioning system. And it's also an argument that is used by a sanctioned state against the sanctioners. It's like, well, you're sanctioning me for this breach of international law, but there are other breaches that are happening. So that's also one of the things I think that we should take into account into this discussion on enforcement. And just on that note, the reason I bring this up is because the US who has had these really strict sanctions against Venezuela, is basically turning to Venezuela in order to buy oil from them, because they can't afford, apparently, not to buy oil from Russia. So, and Venezuela, a year ago, the US was basically trying to remove Maduro from office and have Guaido there. But now they go to Maduro to buy oil. So from a policy perspective, I really strongly find that it's such a it's such a bad signaling, and signaling is really important in order for sanctions to work. Yeah.
Thank you very much, Alexandra. We are 12 minutes beyond the schedule. I think that we have unfortunately already reached the end of this webinar. I would like to thank very much the speakers for providing us with this incredible amount of critical knowledge. Our community definitely strongly benefits from this. Thank you very much also because the intervention were made on such a short notice. And I also would like to thank very much my colleagues, and in particular the director of the research group on international law, Patricia Hobbs and Solon Solomon, who have played a critical role in making this event happen. Thank you very much. I wish you a very nice evening, and I hope that this is only the very beginning of a future fruitful dialogue among us.
And for my part also, Dr. Sullo, to say also the participants, thank you very much. And to say to the attendees also that the next event of the PUL International Group is going to be on the March 28th for the Law of the Sea. And with this, we close the meeting, and thanks very much for the participation to everybody.
Thank you all very much.
Thank you.